Good day, folks. Welcome back to Ancestry Legal, the law firm that specializes exclusively in estate planning to bring you the best possible products and solutions for your needs. Joining me today is the business owner, Melissa Belcher. Thank you so much, Melissa, for your time. As we continue in our Q&A session, great question that has come up is, can I make sure the guardians for my children receive the funds they need to care for my minor children and over their hobbies, their education, their sports, housing, healthcare, etc.? Can I make sure that the guardians are going to receive those funds?
Yes, absolutely. I mean, this is what we do in a trust document. So in estate planning, if you have minor children, you would use the will to nominate the guardian, but then within the trust is where you would put in all the terms where the guardian could either directly receive funds for all of the needs, the housing, food, sports, education, healthcare for your minor children, or you could have the trustee pay those expenses directly. So either way, a trust is the way that you do it. And yes.
All right, excellent. The next question is, what happens when my minor children turn 18? As far as the children being able to pay for their own living expenses, education, etc., or does that have to be handled by the trustee? I think you said,
Yeah, so it's your
or the
trust.
guardian.
It, it's your trust. It's your rules, and depending on when this happens, when you write the will, some young adults are very financially responsible. Other young adults may not be. How much money is it? But you can actually write it in there where they get a small chunk when they turn 18 or when they turn 21. It just depends on what you desire. You can have, instead of them the funds paid directly to distributed on a monthly basis directly to the guardian, you could have those paid to the young adult so that the young adult can then pay for his or her own expenses, or you can have them paid directly on the young adult's behalf. I don't know if you remember, and since you weren't in the US, do you remember when Whitney Houston passed away?
Yes.
And she wrote her will before she actually had her daughter, Bobby. And then after Whitney Houston drowned in the bathtub in LA, shortly thereafter, her daughter inherited, her mother's estate, which was a significant amount, millions of dollars for a young adult. But then the daughter voluntarily agreed for that money to be transferred to a trust. And it was really to protect her because, this is a very public situation. And, people would target her. She was vulnerable emotionally. She had lost her mother. They were very close, and then she had access to a significant amount of money. So, there's many different reasons why you would want to keep it private and keep the funds in a trust that is there for the child's benefit. So the child doesn't go without anything, or you're going to make sure that it lasts for a period of time until they can get to a certain point of financial maturity.
Okay, excellent. Thank you. So I think I would like to be a fly on the wall in this process because it sounds to me like after you have passed is probably the only time you can guarantee that the entire extended family will have to live by your rules and they can't bend them, change them, or argue them with you. So write them into the trust. It's your rules, it's your will, and that is what will get executed. Thank you so much, Melissa, for sharing with us today. And folks, remember again, if you need any further information or you want Melissa to assist you in this regard, Melissa at ancestrylegal.com. That's the way to reach her. And look forward to seeing you on the next episode. Thank you, Melissa.
Thank you.